do his business on my seat.
At least he didn't like chew seats and stuff.
No, he doesn't do that.
Good evening, it's 5 o'clock, and welcome to the Kodiak Island Borough's Assembly Special Work Session. Tonight, we're going to discuss quasi-adjudicatory training, boy, I hate that word, with the borough attorney. First, we have citizens' comments. Citizens' comments can be phoned in at 907-486-3231 or toll-free at 1-855-492-9202. They're limited to 3 minutes per speaker, and if you're in the room, please sign your name in on the sheet and announce your name for the record. Thank you. Any citizens' comments? Go ahead.
Good evening, ladies and gentlemen. I've meant to come to the last few meetings to tell you thank you. Thank you, thank you, thank you for lowering the mill rate. I vote the way I do because of certain senior citizens. One lady that I've known for about 60 years cleaned houses out at the base, and then she also raised her kids. Her son built her house, and she used 3 credit cards to buy the supplies. And then I know other people that do not heat their houses ever. And so that's why I vote the way that I do. I've slept on people's couches and been invited to come over and watch movies. So I climb into their bed with them, get under the electric blanket. We have pie and tea and watch movies. And then I go home in the cold, or I go to someone's house and I keep my jacket on and my hat and my hood. And I think at my age, I'm just going to decline from now on. But lowering the mill rate is why I voted for Scott Arndt at the last election. So I appreciate your vote. Thank you. Oh, Carlene McChesney.
Any phone calls? Any other citizens' comments? Okey doke. I guess that's enough of that. Now we'll move on to the borough attorney. Hi there, how are you?
Doing well. Thank you. It's good to be here. Scott Brand Erickson, I'm the borough attorney, and I'm here to talk about administrative adjudication. I understand that some of the folks in the audience may be on the Board of Equalization, some may be planning and zoning folks, some may be staff folks, and assembly members are here. Each of those groups at one point or another may handle administrative adjudication matters. Now, the planning and Board of Equalization is almost always administrative adjudication. The planning and zoning, some of the matters that they take up when they're considering recommendations for changes to zoning or comprehensive plan things are legislative type decisions, making advisory recommendations. But an awful lot of what they do is adjudication. And the difference, one simple way to tell the difference is if it's legislative, then you're setting policy. If it's adjudicative, you're applying policy. And if it's legislative, there's no appeal. It's not something that goes to the courts. You know, a party may challenge whether you followed the right procedure to adopt whatever it is, or challenge the constitutionality of whatever you've adopted. But there's no judicial review of the wisdom of that decision. Generally, the court will defer to the legislative judgment of the assembly or the legislative body. In an adjudication, you're taking the facts of a particular situation, you're applying the law, whether it's the code or principles of assessment, what have you, to the facts of the case and making a decision. Now, Most of the administrative adjudication hearings that you have are what's called on the record. And that means, for example, for the Board of Equalization, the assessment department will make a determination as to the value of a parcel, send out the assessment notice, and if someone is challenging that valuation, the Board of Equalization is reviewing the assessor's determination. And in order to overturn that decision, there needs to be, out of a 5-member board, 3 members have to vote to change the assessment. If they don't have 3 votes, then the assessor's decision is upheld. And they're reviewing what the assessor presented, but they also are taking evidence from the appellant. In a planning commission, when the planning commission hears a case, an application for a conditional use permit or for a variance, they're making an initial decision, and they're holding a hearing, they're taking testimony, they're receiving public comments, and then they're applying the criteria. And for example, for variances, the 17-195-050 sets out the criteria to apply, and they need to find that that criteria has been satisfied. And if they don't find that, then they have to reject the application. Similarly, for conditional use permits, 17-200-050 has the same. There's criteria to apply. If the applicant meets the criteria, then they grant the application. And those decisions are made by majority. The Planning Commission also hears appeals from decisions from the Director of Community Development and Planning, and when they're hearing an appeal from someone else's decision, then it's on the record. And in order to overturn the decision, they need to have a majority vote to overturn it. If there's not a majority, then the lower decision stands. Similarly, for Board of Adjustment, if the Assembly is sitting as Board of Adjustment, when you're reviewing a Planning Commission decision on a conditional use permit or variance, you will review it on the record. There are some particular rules for Board of Adjustment procedures. There's a limit on who can appeal, and you're not supposed to take new evidence at the appeal hearing because it's confined to the record. If there is new evidence, then you'd send it back to the Planning Commission to hear the new evidence and make a decision. But you would determine whether the Planning Commission whether their decision is supported by the evidence in the record. Yes?
Is it okay to ask questions?
Certainly.
So if they make a decision to overturn administrative, then they have to base it on a finding of fact. They can't just say, we disagree with it. They have to say, we disagree with it based on X, Y, and Z. And those would be the facts of the case. It's not just automatic yes or no.
That's correct. And not just any facts, but the facts have to relate to the criteria that they're supposed to apply. Yeah. Quite often, the staff will prepare proposed findings for the criteria. There are 4 or 5 criteria for variances and for conditional use permits, and all of those criteria have to be met. If the Planning Commission is approving a permit application, they are making findings that each of those standards or criteria have been met. If the Assembly, when they're sitting as Board of Adjustment, wants to reverse that, then they need to make findings of fact relating to how the Planning Commission got it wrong and those criteria are not met. And if it's an appeal from the director's decision to the Planning Commission, they would make findings of fact, form their conclusions that explain the reason for the decision. And if they, let's say it's a conditional use permit that the director recommends, the report recommends it, and they want to reject it, they may have to come up with their own findings and conclusions as to whether it meets the criteria or why it doesn't. Yes.
So if I were making a motion to overrule judicial decision. My motion would include, I move to, in a positive way, but I should list the findings of fact that I'm basing my motion on at that time. Or that the ex post facto or after the fact.
It would be nice to do that, but you don't have to do it that way. You could have your reasons for the decision provided in discussion. For example, you could move to reverse the decision of the Planning Commission and grant the permit, and then motion is seconded, and then you explain the reasons for your motion or the reasons to support that. And what it comes down to is when a matter gets appealed to court, the court is going to look at the record, the facts that were introduced at the hearing, and the findings that were made by the Board of Adjustment or the Board of Equalization. And if they can't tell what the decision was based on, then they're going to send it back for more findings. The findings need to be adequate to provide a reviewing court the information as to the basis for the decision, so that they can judge whether that basis, the reasons for the decision, are supported by the record. And the support in the record, the standard for the findings of fact, you may have people who are testifying at an adjudicatory hearing saying conflicting things. And you have to decide which one you think is more true. Board of Equalization lends itself to a good comparison. The property owner says, this property is only worth $200,000. The assessor says it's worth $300,000. If the Board of Equalization determines the assessor is correct, it's $300,000 based upon A, B, and C, then there's a clear record, there's evidence in the record that supports that number. If the Board of Equalization says, well, how about we go in the middle, it's $250,000. If there's no factual basis to support that number, then a court is likely going to send it back for more findings of fact, or overturn it or send it back. So whatever the decision is, needs to be both supported by rational reasoning related to the criteria, and supported by facts in the record. And it doesn't have to be, there can be conflicts in facts, and the adjudicating body can choose who to believe, but the evidence has to be there somewhere in the record to support the factual findings. There are a couple of procedural concepts with adjudication. For the most part, government, particularly in adjudications, we're in the process business. People need to have due process, and the first point of that is notice and an opportunity to be heard. So whoever the applicant is, they need to know when the hearing is, how they can present their information, and they need to know what it is that's being alleged, or what the argument is, and the party presenting the other side has to have the opportunity to respond to that, whether it's in the hearing itself or in written filings ahead of time. So some of the procedural rules, like I mentioned, Board of Adjustment, you can't introduce new evidence. Well, one of the reasons is you're reviewing the Planning Commission decision. If they didn't have that evidence, if they had it, they might have decided differently. So if you allow new evidence to come in at a review stage, then you're not following the process. If one party is providing information to the adjudicative body that the other party doesn't know is being presented, then that can be a due process problem. And where that comes up, you've probably heard of ex parte contact. That's where only one party to the dispute or the issue is communicating with the adjudicator, with the judge. And in this case, the judge might be the assembly, or it might be the Board of Equalization, it might be the Planning Commission. And the way that can come up is if you are one of the adjudicators and you have separate knowledge of the dispute, of the issues, and maybe it came about because one of the parties called you up and was bending your ear on it, and it's not presented in the record, but you're going to base part of your decision on it, that's improper. And so at the beginning of each of the hearings, it's a good practice to first ask if anyone has had ex parte contact with the parties on the issues that you're dealing with. And if you have, it doesn't necessarily disqualify you, but you should disclose that you've had the contact and whether it's going to influence your decision in the case. And if there's information that you received that might influence your decision in the case, you'll want to disclose the substance of that so the other side has an opportunity to respond. An example that you might have if you have a jury trial, you don't want the jurors going off on their own, looking at the crime scene or checking it out and obtaining evidence on their own that's not presented in court, because the information that the decision is based on is supposed to be what's presented, not what you went and dredged up on the internet or from your own research. If you do happen to do your own research and you're going to be relying on that, you should disclose it so that each side has a fair opportunity to respond. Yeah.
If you're introducing new evidence, as you're suggesting here, when is the proper time to do that? I mean, don't you have to postpone everything until everybody's dealt with that information?
Quite often, that's what a court will do. It makes a difference if you are hearing it as an appeal, as a Board of Adjustment, then you shouldn't take the new evidence at all. If you have had the ex parte contact and you can't ignore what the person told you, you should disclose it and perhaps not participate in the decision. You can know things that are common knowledge, like intersection of these two streets. There's a building on that corner. Things that are generally known, that's not ex parte information. I mean, people generally know that there's a creek here, the airport's here, general things like that. But you shouldn't go out and perform your own investigation regarding a thing that you're going to be hearing as an adjudicator. It's up to the parties to present their information. And if you think there's other information that you really think they should bring that is needed to make the decision, well, if the body feels that they need to do that, you can ask the parties to present additional information on the topic. But you shouldn't be going outside of the record and bringing in evidence that was not presented by the parties. Now, when you're an elected official, a lot of times people will call you, and they'll leave messages on your phone. You can't avoid people calling, but if it's an issue that you're going to be called upon to be a judge on, as soon as you figure out what the topic they're talking about, you should try, if you're talking with them in person, you should try and stop and say, I can't talk about that because I'm going to have to be one of the adjudicators, one of the judges on this issue. And if they go on anyway, disclose it and declare whether you're going to rely on the information or not. If you're not going to rely on the information, disclosing it takes care of the issue. A second point is having an unbiased decision maker. And if you have say for example, there's a jury and the charge is child molesting, and you have someone who has such strong views on even just the charge of child molesting that it doesn't matter if the person did it or not. If they're charged with it, I'm going to find them guilty. Well, that would not be an unbiased decision maker. You may have opinions, but when you're making an adjudicative decision, you have to be able to hear the evidence, hear the testimony from the folks, and be prepared to depart from whatever your inclination might be and decide based on the facts that are presented. Yes?
So how does that play into effect when we've got maybe an enhanced level of understanding or subject matter expertise in a certain area, and someone is appealing, I'm just going to use environmental. So somebody wants to talk about environmental work. So how would you factor in an unbiased position when that's your subject matter expertise?
It's a good question. Knowing something doesn't make you biased. It may change how you view the evidence that they're presenting, but and it may change the degree to which you believe what they're saying. But you're dealing with the facts that are being presented to you, and whether you believe this side or this side, you're not presenting the evidence yourself. I mean, if it's a law of physics or chemistry or something, you can recognize that. That's not a fact specific to the case. See if I can think of an example.
Thermal fusion. No, I'm just kidding.
Yeah, well, okay. If you have an uphill neighbor and a downhill neighbor, and they say, well, the water's running uphill. You say, no, the water's not running uphill. You don't need to know exactly what's happening there to know that water doesn't just run uphill. And I mean, it can be more complex than that, but your expertise is not, if you have examined the particular property and you have specialized knowledge of that property, that would be an issue. That would be, ex parte information sort of thing. But if you know that, well, you can't weld these two substances together, that would be general, expert knowledge, but not tied to the facts of the case necessarily. Is that helpful?
I have a last one.
Okay. Yes.
One time, I had the fortunate experience of being selected for jury duty many years ago. I indicated to the judge that I'd be the candidate for a new family. And he said, Judge Mattson said, so everybody here knows everybody. The question is, can you make a good decision based on the law? And I said, well, yes. But I'm sort of getting the feeling that if we know anything, that we would have to excuse ourselves. And that's difficult in a small town where you tend to.
Yeah. No, what you said about Judge Madison, that's exactly right, and that's what I'm trying to say here is, you can know the people, and you can know things that are generally known, but let's say the case was, one driver ran into another driver. If you saw the accident happen, you have special knowledge of the case that is particular to those facts. Or in the case of the parties, I know so-and-so, and I know they're a liar, and they always lie, and I'll never believe them. Well, you're biased. If you're coming to the case and you're not going to believe that person, you shouldn't be on the jury, or you shouldn't be the judge, because, I know them. Is there anything about what you know about them that can prevent you from being an unbiased decision maker in this adjudication? That's what the question is. Let's see. The next concept is a standard of proof. Different cases have different standards of proof. Generally, for anything that the Board of Equalization is doing, the Planning Commission, the Board of Adjustment, the standard of proof is preponderance of the evidence. Is it more likely than not? There are issues that have to be proven by clear and convincing evidence. Criminal cases, it's beyond a reasonable doubt. But for the most part, what you're doing is preponderance of the evidence. Is it more likely than not? And the burden of proof is usually on the applicant, the person who's trying to get something, whether it's trying to get their assessment changed, trying to get a permit, whoever's trying to get it, they have the responsibility to establish their entitlement to whatever it is. Sometimes there are other specific laws that guide the decision. I mentioned the conditional use permit and variances. There are specific criteria. Board of Adjustment, you're sort of looking at the same criteria, whether it's variance or conditional use permit, and applying, looking at the facts, looking at the criteria, and deciding whether it applies. I mentioned the substantial evidence standard, whether there's substantial evidence to support the findings. If in a conditional use permit there are complaints, so this operation is noisy, Planning Commission puts a condition on it saying, okay, you can only operate between 8 and 5. And if they operate between 8 and 5, then that's a tolerable amount of noise. It's not going to materially adversely impact the neighborhood. If you believe, based on the evidence, that no, even 8 to 5 isn't going to work, it's got to be noon to 5, if the substantial evidence supports that, fine. But if all of the noise evidence has to do with the middle of the night, well, there's not substantial evidence to support changing it from 8 to 5 to noon to 5. Because the problem that they were trying to avoid is noise in the middle of the night. Tonight you have a number of senior exemption requests, and the process that the borough has used for those has changed some over the years. I don't recall if it was 2014 or so, but first, the general process across the state. There's a statute, 2945030F, where people file for a senior exemption, or apply for an exemption. If they're late, what do you do? Well, the statute says that the assembly, for good cause, can determine that late filing is okay, and accept the filing, and then have the assessor process it. The borough went through a time period where those late filed appeals, the feeling was that it was too lax. And so an ordinance was adopted that set up a process where the assessor would make an initial determination, and then there would be a potential appeal to the assembly. And that same ordinance also spelled out some specific criteria for what could be good cause and what wouldn't be good cause, because good cause to one person may not be good cause to another. There was a challenge to that ordinance about 2 years ago, and the Superior Court here in Kodiak ruled that the delegating that decision-making to the assessor was not permitted by the statute, that the assembly has to be the one to make that determination. So the ordinance was amended again. The criteria was kept the same, but That's why they started coming back to the assembly to determine whether there's good cause for a late filed appeal, or a late filed senior citizen application. Yeah.
Can you restate that? Did you say that the statute limited the assessor's ability to determine good cause?
That's what the court said, yeah.
And that was
Superior Court?
Yes, and it was a case involving the Kodiak Island Borough, and so it's binding on the Kodiak Island Borough, yes.
Was that determination made on the basis of the language in the code?
In the statute. The argument.
The state statute? not-
Yes.
Okay.
Yeah, the state statute provides that the governing body for good cause shown may waive the failure of a senior exemption applicant to file by the deadline. And the process that was in the code at that time, when the case was brought, had the assessor make the determination, and then that determination could be appealed to the assembly. And one of the arguments that the fellow made to the court was having the assessor make the determination is in conflict with the statute. You can't do that. The statute says the assembly has to make the determination, and so that's the only process that can be used. And so what happened in that case is it was sent back, and the assembly then made the determination whether there was good cause or not. So that's why the assembly has to decide on each of these late letters, the late filed applications, whether the excuse, whether the reason that it's filed late establishes good cause. Yes.
So, the assessor, the only responsibility they have, or power, if you will, in fiduciary authority, is just to say this application was late.
They can also present their view as to whether they think the assembly should grant it or not, but that's not their decision. You're not hearing an appeal from a decision. You are the initial decider. And a difference in that is, for example, when the Planning Commission gets a variance application, they're hearing testimony from whoever's in favor, opposed to it, and taking evidence, and then making the decision, making the findings. For these senior late applications, you are making the initial decision. You're not reviewing it based on the record. And so you'll hear arguments from the applicant, and you'll hear arguments from the staff, and then you would decide, based on the evidence that's presented, is there good cause or not? And in making that decision, the statute, excuse me, not statute, your ordinance has some guidance. Good cause shall mean extraordinary circumstances beyond the control of the applicant, including but not limited to a medical condition or disability, impaired mental capacity, family emergency, death in the family or similar serious condition or event that substantially impaired the applicant's ability to file a timely application, shall not mean late filing due to the applicant's inadvertence, oversight, or lack of knowledge regarding the filing requirements or deadline, financial hardship, or failure to pick up or read mail or make arrangements for an appropriate and responsible person to pick up their mail. So before this standard was adopted, it just said good cause. And my understanding, I wasn't the attorney in 2014, but my understanding is that there was concern at the time that the basis for the decision, whether to grant or deny, could be arbitrary. Two people who had similar fact patterns, one might get it granted and one might have it denied. So when you're determining these, that's your criteria you're applying, similar to when the Planning Commission is applying the factors for granting a variance or a conditional use permit. And you're making the initial decision.
So, just, I want to make it really clear.
Ryan has his hand up first.
Well, I was following up a question before we got here. Get my focus back here. So we're not overruling. The assessor's responsibility is to let us know, and they give information as to why, but there's no overrule. There's no going beyond the assessor. We're making the decision, and the decision relative to what is extraordinary is really based on the opinion of the assembly member and how they interpret the information in front of them. Collectively, as they vote, there's an outcome. but it seems like there's a lot of room there for defining extraordinary.
I agree with what you said about the assessor is, you're not reviewing the assessor, they're providing evidence which may be helpful to you in making the decision. As far as extraordinary, the definition that you have in the code does provide some guidance. It gives examples of, what is or might be good cause, they're in the hospital, what have you, or what wouldn't be good cause, my dog ate my homework, I didn't check the mail, it says those are not good cause. So within those parameters, if the justification is more similar to death in the family or in the hospital, it's more likely to be, extraordinary, beyond their control sort of thing. If it's more like, I forgot, well, then it's more likely to fall on the other end where, no, that the ordinance says things like that are not good cause.
Ryan?
I hate to take you backwards,
Yeah.
and not to put you on the spot. Do you have a reference name or number for that decision that was made by the Superior Court 2 years ago?
It was Mel Stevens' appeal of his denial of his senior exemption, and I don't have the case number, but
We can get that.
yeah, it's available.
And the second thing is, in the Kodiak Borough ordinance, it also says determination of good cause examples, but not limited to.
Correct.
I believe that might lend itself to what Larry's talking about with ambiguous terms. Should versus shall type scenario. So I appreciate it. Thank you.
Yeah, when, in a statute, when there is a listing of things, there's the Latin term is a justum generis. When there's a listing of things that are examples, other things that are similar in nature would generally be included. And things that are not similar in nature would not be included.
Categorically included.
Yeah, so, you don't have to enumerate every single thing that might happen, but, if a dog bite, a cat bite, a scorpion bite, they're all animal bites of some sort. But you wouldn't have to list every animal that might bite you.
Understood. Thank you.
Was there another question, or?
That was all.
And the reason, what you're trying to do, well, you want to make the right decision. But what you're also trying to do is make sure that the record that you create would give a reviewing court an adequate basis to understand the decision. Now, there's a recommended method, and I think it's the standard method the Planning Commission uses, where you have the hearing, you have proposed findings. If they adopt the recommended findings, then you've got the evidence in the staff report, you've got the recommended findings, and they adopt the findings, you have a decision that says this is a decision and this is why. And that decision is then issued. If they don't follow the staff recommendation, they might articulate their reasons on the record, say, this is why we don't think this is right, and then the staff would come back at the next meeting with the decision written up with those findings and get adopted. I think Board of Equalization and Planning Commission both commonly do that. And that's ideal. I have had cases, actually one of the ones that I was referring to on that standard of whether the court has an adequate basis to understand what the decision was based on. It was a Board of Equalization case, Alvarez, in Ketchikan, and she had two lots, and she was saying they weren't worth what they said they were. She said they were only worth $30,000, and the Board of Equalization rejected her appeal. The written decision didn't specifically say why, but fortunately the transcript of the debate on the issue, individual Board of Equalization members, and the assembly sits at the Board of Equalization, so they do these hearings every year. They explained exactly why they disagreed. There's two lots down the street that are for sale for the same amount the assessor listed these at, that sort of thing. And so I was able to defend the decision But, you know, she had a reasonable argument because there were not specific findings. So it's best if there are specific written findings explaining the reasoning. Using the example of the late senior applications, you know, statements to the effect of the, you know, finding that there was good cause because blah, 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 whatever the facts are that you believe establish good cause in that case, because that helps differentiate it from the listed items that are not good cause. It helps explain why it fits in this category and not in this category. And like I say, you're making the record for a reviewing court. Now, a lot of times people won't bother to appeal to court, but they could. If it's a denial, the applicant who has the permit denied may be motivated to do it. If it's a grant, you know, on any of the tax-related things, it influenced the city's tax revenue. The city or the assessor could appeal the decision. On a Board of Adjustment, it could be you know, a neighbor, the applicant, you know, someone who is within the scope of the folks who are adversely affected by the decision. That's pretty much what I had to present. Yeah.
Would the doctor's written report suffice?
E-
Say if somebody fell and their spouse fell and they had COVID also, would that suffice for this good cause? Showing to waive for the senior tax exemption, refiled application with a doctor's written, my ex-husband has just fallen 3 times in Anchorage, and he went to the doctor and it was all written up, so he was able to change his plane reservations back to New York about 3 times because he wasn't up to traveling.
Yeah. The best answer I can give is potentially. It would depend on all the circumstances because, for example, if the doctor's notes said, you know, from January 10th to February 1st, they were out of commission, they couldn't do it, but they didn't do anything for 12 months, you know, or you know, 8 months, well, what about the other 7 months? So it might provide good cause for a time period, but not necessarily for the entire time period that they were late. And so it depends on all of the facts, but it certainly would be good evidence. Yeah.
Jared's got some questions.
Yeah, I have a few questions. I apologize if we're backtracking a little bit. I want to make sure you talk to see if you answered some of them. My first one is to clarify some definitions regarding standard of proof. What is the difference between more likely than not and substantial? In my understanding of law, which is like this, more likely than not is like a 51 to 60% kind of feeling that something is true, but substantial, you're getting more into like the 80, 90, 95% feeling that something is true.
Mm-hmm. They don't assign percentages.
Sure. Yeah.
The 80, 90% is probably more beyond a reasonable doubt almost, you know.
Okay.
But, you know, 51% could be preponderance. The substantial evidence is a different concept than the standard of proof. Substantial evidence, the idea is if you have property values are an easy one to use an example. If you have 10 people get up and say, this piece of property is only worth $50,000, and you have one person get up and say, you know, this piece of property is worth $75,000 because it has all the attributes of this one, that sold for $75,000. It's not the number of people that testified or the predominant opinion. If you then said it's worth $75,000, it doesn't matter that 10 people said it was $50,000. There is evidence in the record that supports what you decided, and you decided you believe that more than the other one. Now, in making that decision, you're deciding that it's more likely than not that it's $75,000. But if you didn't have that testimony and you said, no, I think it's $75,000, there would not be substantial evidence to support your decision because nobody said $75,000. You only had 10 people saying $50,000. Does that explain the difference?
Yeah, I just wanted to, clarify the difference.
I mean, some evidence in the record, somebody testified to this, somebody said this, and you believed it. But if nobody said it, then there's not evidence to support that conclusion.
Can I ask a question about new evidence? When the borough sends out the notice of the adjudicatory hearing, is it the borough's burden to also notify the applicant of the rules around introducing new evidence?
Which type of hearing are you talking about?
Like the senior tax exemption, for example.
It doesn't apply for the senior tax
Okay.
exemption, because a hearing that is the initial hearing, it's all new evidence. You're not deciding it based on the record, you're making the initial decision. The best analogy for administrative adjudication is probably the planning commission when they hear a conditional use permit application or a variance application. They are hearing the public comments, they're getting the reports, they're getting the application, they're getting whatever somebody wants to put out there. Now, when it goes to the Board of Adjustment, they're getting what was presented to the Planning Commission. The arguments that they hear are going to be arguments based on that evidence and not new evidence. If when the initial stuff was presented, nobody said, well, they're going to use aluminum and that causes cancer. But when it comes to Board of Adjustment, somebody wants to argue, well, they're using aluminum, it causes cancer. Well, that's not in the record, that's new evidence. So, but on the senior exemptions, the issue of new evidence, it doesn't prevent you from hearing it because everything is new evidence.
That kind of leads to my final question, which I guess is a little bit more hypothetical. So in debate, we have something called the challenge of imbalance. Like you have novice debaters and you have experienced debaters. And you never put a novice debater up against an experienced debater because of the challenge of imbalance. It's just not fair. And I've received a couple of comments from, or concerns from the community about that kind of challenge of perception of imbalance where you have the borough government that has resources, legal review resources, professional service resources to prepare, written cases, and citizens who are asked to go through this process who don't have those resources. So I guess my question is, how do we respond to that? I would like some advice on that how do I phrase this? Not, advice about considering the challenge of imbalance in deciding adjudicatory cases.
It may
Does that
sound,
make sense?
yes, it may sound cold and harsh, but it just doesn't apply.
Okay, all right, thank you.
Yeah.
That's all I need, yeah.
In court, there is some leeway given to lay persons representing themselves where the court will not necessarily hold them to as rigid a standard procedurally, but substantively, they still have to make the same arguments. For example, somebody representing themselves, if they don't understand, they can't ask a witness to testify as to hearsay things. The court may say, you can't do that, and help correct them or educate them. But they're not going to let them get the hearsay testimony in. And in adjudications that imbalance, it's often present, and it doesn't make you don't have to change the process for it. That's just life.
Thank you very much.
I'm going to take Seema and then Larry.
Sorry. So I just want to know about the outcome. So if maybe a previous assembly ruled on something and now a similar incident is coming up and they're going to rule on it and they rule differently, are we now at risk for a lawsuit from that old case that might have been denied and this time the same situation is being
Well, you don't want the decisions to be arbitrary, and ideally, they're consistent, but, each one is determined on its facts. If you have two that are on identical facts, they should come out the same way. In cases in court, you may have different judges who see the facts differently and reach different conclusions. It's not uncommon. And it may be the same if you have a different makeup of the Planning Commission or the Board of Equalization. They may view the facts differently. And it doesn't necessarily make the process invalid. It does expose you to criticism. And as far as liability, someone may argue that in a particular case, it was wrongly decided because of this prior case. But unless the borough is pursuing a policy of, we're going to just change the way we view these and start deciding this way, that policy may form the basis for a challenge. And they may say, that policy that you're following now, that's unconstitutional, or it's contrary to statute, or what have you. But if it's that individual cases on their facts happen to have different outcomes, there may be many reasons for that that are not nefarious.
Larry.
Just, I may be redundant here, but I think it's important to note, as I understand it, the assessor, if somebody is late, has no choice but to deny it based on the court decision. They don't make that decision. Some people think they do, but they can't evaluate any of these terms that the assembly has to evaluate. They can just say this is late or it's not and deny it based on that. That's correct.
Actually,
They got some
they
leeway.
don't even deny it. They don't act on it. They have to have the assembly deciding that there was good cause for it being late before they would process it and make a decision. It could be that someone filed a late application and you say, okay, they had a good reason for it to be late, there's good cause, and then the assessor starts digging into it and finds out they only lived here 1 month out of the year, and so they didn't meet the residency requirement. Now, I suspect that the assessor may look at that ahead of time, but they may not. And really, they can't grant the application if it's late.
Well, that's my point. I don't want to, I think the assessor needs to be protected. The assembly has been given the responsibility at looking at the nuances of why it's late, if you will, and I think the assessor needs to defend the process, based on the record, but I don't want people to blame the assessor for not acting on the request, if you will, because that would be up to the assembly to make that decision based on the case law that you said. That's correct.
Yeah. The assessor's role is kind of like the clerk at an election. When the ballot box is closed, they can't take more ballots. It's, 8 o'clock, the polls are closed, that's it. And the assessor, same thing, that deadline, she cannot grant an application that's late. She shouldn't make a decision, she cannot make a decision granting it unless the assembly first finds that there was good cause for that
So-
application being late.
She has no leeway. If it's late, it's late.
Right.
Thank you.
Ryan and then Scott.
To piggyback on Seema's question regarding precedents versus episodic decisions, does the assembly have the ability to create letters of interpretations based upon episodic findings? And what I mean by that is on a federal regulatory level, letters of interpretation correct or remove ambiguous terms. Does the assembly have the same ability to do that at our level?
Not in the same way. You have the ability by changing the code and, being more specific or general, whichever way you want to go. But in terms of, what was decided last year or 2 years ago to be good cause, it's not a binding precedent. Ideally, you would be consistent over time. But it's not automatically flawed because a similar case was decided differently a couple years ago. That it could be a basis that the person, if they wanted to appeal the denial, they could say, well, wait a minute, this was decided differently. And it would be a factor that a court might consider, but there may be good reasons for why it was different. It may be distinguishable.
Scott.
I just wanted to clarify, even though the assessor doesn't have the ability to determine whether this is good cause or not good cause in one of these senior concerns, we have an experienced assessor who is making an analysis of the facts as they have been presented to them and given us in part her read on the situation, and that's fair, right?
Correct, that's entirely appropriate. If you were only hearing one side of the case, you're not hearing, well, yeah, but what else should we consider? And so what the assessor is presenting is, these are facts you should consider in making your decision. Based on these facts, it looks like this is the conclusion to me, but there's no, that recommendation is just that. It's a recommendation based upon the evidence that is being presented.
Thank you.
Jared. And then Joe.
Thanks, and I apologize for not using my microphone earlier. All right, I'm going for the bag of worms here. Okay, so process and Robert's rules. During the quasi-adjudicatory hearing, what is the status of Robert's rules?
It's a useful tool for keeping the meeting in order. When you have an adjudicatory body, more than one person, you need some way of keeping order, and so the chair is going to be, directing, it's this person's turn to talk, it's that person's turn to talk. So if Robert's rules are the default that the body uses, then it's as useful a tool as any to keep things going. Robert's rules is not a substantive part of the process and shouldn't be used to obstruct the ability to make a decision.
So even though we, for example, later on today, we're going to move from a regular meeting, which follows Robert rules, into a quasi-adjudicatory hearing. See how easy that is to say? Adjudicatory. It's like poetry. Adjudicatory hearing doesn't necessarily mean that Robert's rules it carries over, or that's like the mayor rules. All right, we're going to follow Robert's rules for the adjudicatory hearing.
I would suggest that that's a good way to have an orderly process. Some of the, I don't recall off the top of my head, and I've done stuff for a number of municipalities, and sometimes I have a hard time keeping straight which is which. There are some boards of equalization and planning commissions that adopt their own rules of procedure, which largely they use Robert's rules, but they have some specific rules that may govern the length of time people talk, or that the applicant gets to speak first and last, that sort of thing. That's not in Robert's rules. That's just rules of the hearing.
Joe?
I'm wondering, how does the different life experiences of the people sitting up here have on effect some of the decisions that might be made? As Seema mentioned about maybe a case might be decided differently than one that happened years ago. Do the different life experiences people have maybe have a different outcome? And if so, I don't even know what the question is, but different life experiences, do they matter, or how do they matter?
It may, depending on the facts. If it's a situation where someone was in a remote area and they were weathered in for weeks, well, your life experience may tell you that, oh yeah, that happens. That's good cause. If you were someone in a big city where you didn't have to fly in and out, well, their life experience might tell them that that's not good cause. I don't know if that helps answer the question or not.
I think it does, because that was my question, was how, because we are all different and we have different definitions of good cause, even with the guidance that we are reading, I think. And so I think that helps me. Thank you.
In deciding, the fact that you do have standards, it can kind of help you to try and look, which is it more like? And Sesame Street has one of these things is more like the others. Okay, you got these things are not good cause. You got these things are good cause. This fact pattern that we've got, is it more like this one or is it more like this one? That's one way to look at it.
Anyone else got any questions? Carly, I'll let you do one more then.
What if the petitioner or the waiver is not a good writer, and they haven't had good counsel as to writing a letter or that brief?
Mm-hmm.
Maybe that's not a good question.
If they know that they are not skilled at communicating their thoughts, they could enlist assistance of a friend who is. But the fact that their ability level to communicate in writing isn't one of the factors that determines whether there's good cause or not. What would determine is the underlying facts. What exactly were the circumstances? Why didn't they meet the deadline? Whether they're a good writer or speaker, they should be able to communicate, okay, what was the reason that they missed the deadline?
The facts.
Yeah, the facts are what's important.
Scott, is there anything else that you have that you want to go over?
I don't think so.
Okay.
As the attorney, the thing that I get most concerned about, and I think the clerk probably gets most concerned about, is that there's a clear record. When there's a decision made, I mean, you mentioned Robert's rules, if there's a motion, we find this, and then someone says verbally why. How it's more like this group of factors, or
So
more like
it's
this group of
findings.
factors. The findings, yes. If there's a clear basis for the decision, it may be the wrong decision, but the reasoning is clearly explained, then when it gets to the reviewing court, they don't just send it back.
Thank you.
Yeah.
With that, seeing none, we'll end the work session. Thank you, Scott. Take a break here till 6:30. Working. Oh, yeah. Supposed to be in 6 different places. Bullshit. But I had one-on-one training.